is going to be a slightly different format than the usual trainings we've done. It's going to be a whole lot less of me pointing at sections of a specific form and more of me bouncing back and forth across the library and explaining reasoning rather than actual context of forms. So that's our plan today. We'll start, it looks like it's 10 o'clock on the dot, so let's start this thing up. There are only 4 people in the audience today, so it's one of those trainings. Let's get into it. This is the Avoiding Legal Trouble with Oregon Realtors Forms. My name is Nicholas Peasley. I'm one of the staff attorneys at Oregon Realtors. When we talk about this training, we're talking about how to avoid legal troubles. When we say legal troubles, we're talking about basically the problems that exist in the world writ large for real estate licensees. The Oregon Realtors Forms were drafted by a combination of the staff attorneys at Oregon Realtors, who are the legal hotline and various experts on the forms that exist in the real estate market, as well as a task force of principal brokers. Once we had the forms ready and reviewed by the task force, they were secondarily reviewed by content specialists and practitioners for various adaptations of the forms. So, for example, the manufactured home and all that stuff got reviewed pretty heavily by manufactured home specialists. The libraries themselves have some pretty distinct changes that were made from the original standard of practice, kind of like the way things were being done up until 2020. And those were based in large part on our task force's more than a century of kind of practical knowledge in the industry, principal brokers who have said, would be able to say, I had this problem, it was caused by this portion of this form, I want it changed, and we can make those changes to those forms based on essentially people saying this was what didn't work. As well as all of our background knowledge from the legal hotline, which we've had going for, I think, close to 2 decades now, or potentially more than that. It's well before my time. And then also commentary from the membership at large. We did a fair number of talks to members statewide, and we got feedback from members that was then integrated into all the forms. So for this training, what we're going to be doing is there's a format to it. The first thing is I'm going to present a scenario. It's an issue that is based in a scenario. The scenario is going to be an abstract scenario. You can be absolutely certain this is based on a real scenario that we heard about in the legal hotline, but I'm not using people's names and I'm not calling them out. If you happen to be one of the people that this scenario is drawn from, you don't have to call yourself out in the chat. It is okay. Just kind of let it be silent in the meeting. We'll then talk about how that issue was in general has caused some sort of a risk, how our forms address that risk, and if necessary, we'll show you how to fill out the relevant section of the form in the way that addresses the risk and is the proper usage of the Oregon Realtors form. So that's a step approach to this training. Issue number 1, it's on advisories. That's on the right-hand side, that's a picture of forget-me-not. That's because there is very little copyright-free imagery in the world that talks about how someone forgets something. So in this case, we're talking about forgetting something. The scenario is you represent a buyer. You are a buyer's agent, and you want to help that buyer purchase a property. The buyer makes an offer on the property with their normal packet of various documents, seller counteroffers, and adds a couple things to it, including a well addendum and a historic property addendum. The buyer didn't know there was a well. Whoops, you didn't have that addendum on the document when you did that. You didn't know the property was in a historic district. Who knows what historic districts there are in this state anyways. And because of that, the offer's buyer, even though it was good, it was incomplete. So the seller's counteroffer completes the offer. Buyer accepts that counteroffer. Halfway through the transaction, the buyer pauses and asks you, hold on a second, what's a historic property district? Like, what is this historic property thing? And you realize, oh no, I never gave you the historic property addendum. You don't know about the historic property and what that means. There might be a tax assessment that comes down the road. There's information that needs to be, that the buyer needs to know about these historic properties, and that was supposed to be an advisory that I was supposed to give you. Advisories, the reason why this creates risk is an advisory is designed to give you the client protective information. It's something the client needs to know before that thing becomes a problem. It is meant to advise them so they can make informed and clever decisions about things that they're passionate about, they want to spend their money on. Delivering an advisory to a client after they're under contract is more likely than not a violation of ORS 696-301-15. That's the things that the Commissioner of Real Estate can punish you for. Essentially, 15 says it's below the standard of practice, and the standard of practice industry-wide is you give people advisories before they start their contract. Because once you give an advisory after the contract, it's basically telling someone, I'm sorry, here's something you should have known about before you bound yourself to a contract. Whoops. That's below the standard of practice. You can literally be punished for this sort of thing. So what we want to do in our advisories, what we did in the Oregon Realtors context, is we put all the advisories in one place. I know that the Oregon Realtors buyer and seller advisory are a lot, and people have said that. It's like 27 pages. Come on, I don't want to give my client that. Why is it 27 pages? Because it ensures you have not forgotten anything. All the advisories you need to give a client, all of them are in one place. It makes sure that one email has all the advising you need to do. It isn't something where you're trying to like, oh, did I remember to give them the recording information thing? The seller says there might be a camera on the open house, so now I need to send them that advisory. It's not, it's all in one place. So one send covers all the information. If you send a single document and has everything in it, you've met the standard of practice. The buyer and the seller will then acknowledge their receipt of this, and that is a paper shield for yourself that says, I gave them the information they needed. You simply send the client the whole comprehensive document at the onset of the transaction before they're even bound under the contract. The client should basically is in the advisory. They're told, make use of this regularly. You should go back to this. Look at it. It's for your information, and knowledge is power in these transactions. So make use of this advisory regularly. Read it at the start. It's important to read. But beyond that, keep reading it, keep looking at it, because it is important. When the client signs the acknowledgement, which is this little thing you see here, this is the last page of the advisory, it then essentially creates a paper trail that says, I, the broker, have done my job. I gave them all the advising they needed. All of the pre-existing advisories have been granted. How do you use it? Well, for Oregon Realtors Forms, we start the contract off in the purchase and sale agreement saying buyer and seller should have acknowledged they've read and understood the advisories respectively. You should give it to them, and they should understand it before they even go under contract. If they don't read it, then by signing the contract, they're essentially saying, I understand that I was given the advisory, but I'm pretending I read it. And even in that case, you've met your standard of practice as long as you, the broker, have sent the document to the client. So just make sure you give them the advisory before anything becomes a problem. If you're not using Oregon Realtors Forms, using a different library, use all the advisories you can get. Send your client a giant package email that has all of them, because that's the best way to protect yourselves. In the Oregon Realtors context, we put all the advisories in one place. Now there is additional advisory, like in the pack. If you look in our library, document 10.5 is the wire fraud advisory. There is wire fraud advisory language in our buyer and seller advisories. It's just a split away separate document that's made its own one-page advisory, because in a lot of cases people like being able to give that document to their client twice to basically say, if you look in the advisory, it'll tell you about wire frauds, but also I really want you to remember to think about wire fraud, because if it goes wrong, it goes really wrong. And so the wire fraud advisory is the one that's been kind of doubled up on. Issue number 2, and I'm going to kind of blaze through these because I've got I think 12 issues to cover on this one that we're going to talk about. This is a mandatory inspection before termination. Some form libraries will require that the inspection be done before you can terminate during your inspection period or your due diligence period. So scenario, buyer's sales agreement only permits buyer to terminate if they disapprove of the property based on one or more of the inspection reports. 2 days after the buyer's offer is accepted, the buyer receives their dream job in Sheboygan, Michigan, and they need to terminate that contract because they're not going to live in Oregon anymore. They're going to live in Sheboygan. We chose because it has a funny name. That's the whole reason it's in this transaction. Sheboygan has a fun name. The buyer hires the cheapest and fastest inspector they can possibly get to look at the property. The buyer terminates as soon as they get that inspection report, and as soon as it comes back, they don't even open the attachment. They don't care. They just forward it directly to the seller. The seller is now upset because the inspection report says the only issue I could find was a couple nail holes in the drywall that needed spackle. Basically, the inspector said, this house is spotless. It's perfect. It doesn't happen often, but it does sometimes happen where you'll have an inspector that says, I was really reaching to find something wrong with this house, and the only thing I could find is, I don't know, maybe the roofing is an old style and people nowadays like it when their roofs are made of metal. That's the only thing I could find. When the seller gets that report as the reason for the termination, they're reasonably upset. This is a picture of Sheboygan. It's a pretty place. It's a nice little town in Michigan. The seller is reasonably going to argue buyer didn't disapprove of the inspection reports because the issues could have easily been repaired. The buyer just used that inspection as a Trojan horse to terminate this contract. It wasn't because of the inspection. It's because buyer wants to move to Sheboygan. That's the reason why they want to terminate. The buyer is now out several $100s because they had to pay an inspector. The seller is pissed off at the seller or the buyer and the buyer's agent because they feel like it was a pretextual termination. And the earnest money is now tied up in a disagreement between the buyer and seller because they're fighting over that, because the seller feels like they're being cheated out of earnest money because the buyer didn't terminate for a reason that the contract allows. Specifically, it wasn't because of the inspection report. It had nothing to do with the inspection report. That's a problem. In the Oregon Realtors Forms, we modified that. In our due diligence provision, we basically said you don't have to have a reason if you're terminating during due diligence. There's no pretextual inspection that is required to justify your termination. The buyer simply gets 10 days during which they can do any of these inspections they want to or terminate. They don't have to terminate for a reason. It can be any reason. It could be the sky is blue today. That's why I want to terminate. That's acceptable. And the reason why it's been done this way is essentially to prevent the scenario from happening that we just put out there. It comes up on the hotline more than a couple times a year, and you would be shocked by it because it feels like something that shouldn't happen. The buyer does have a due diligence period in our contracts that let them review the property for various reasons. I see a question in the chat from Veronica. Is that the same with OREF? OREF's contract does require the termination in the inspection period be based on the inspection, based on an inspection report. So you do need based on the reading of it, the literal reading of the contract in the purchase and sale agreements in the ORF library, you would require an inspection report to activate that termination because it must be based upon an inspection report. If you haven't done an inspection, you can't terminate under that contract. That's the literal reading of the language. So we have a due diligence period. You can look into all the other stuff and terminate if you don't like it. The inspections can be done during the due diligence period, but they're not required during due diligence as a reason for termination. If you want to terminate, you just grab Form 5.3 as a buyer and you check the box that says, I disapprove of the property during the due diligence period. Ta-da! No questions asked. Contract is terminated. You don't need an inspection to do that. Scenario 3, a seller's repair process. This is one that happens more often than you think. Scenario, we're going to do it in steps. Step 1, buyer and seller go under contract. Step 2, the buyer requests that seller repair a hole in the drywall where the wall-mounted television was removed. So they plucked the TV out of the wall and they left a giant hole in the drywall. The seller agrees. They want to fix that hole too because they want it to be a nice house. The seller has a friend who's a contractor. Their friend does the job and they do a bad job of it. They are not doing a super professional job. Buyer gets a notice of the completed repairs, does an inspection, and sees that the repairs were not done to the buyer's liking. Seller refuses to redo the repairs because their friend is a contractor and they trust them. So what happens when a buyer gets a notice that the repairs are done? They go back and look at it and they say, these repairs were done terribly. What the heck? This is not a good job. What happens when the seller refuses to do the repairs? Well, what a buyer wants out of a repair and what a seller wants to do in a repair is oftentimes very different. Sometimes the buyer says, oh yeah, you got to repair this thing, and the seller does the bare minimum job and the buyer expected something at a much higher level of expertise or something very different. If it's something along the lines of like, I want you to fill in the nail holes, the buyer might be expecting that the seller fills in the nail holes with spackle and then paints over it with the same matte color paint as the wall so you can't see, if you go to the side where you can see the parallax, you don't see that there's those matte places where they fill it in with spackle. They might expect something different. And the seller, on the other hand, might just think, I just need to go to Home Depot, get a little thing of spackle and squish it into each one of the nail holes. When your form only requires something like the repairs be done in a workmanlike manner but provides no further steps, conflicts over repairs will oftentimes be resolved only in a lawsuit or a dispute resolution. In our contract, we have a notice of completion repairs that sets up a buyer's reinspection period. If the repairs that were done were not satisfactory, if the buyer says these are not done right, the buyer can notify the seller and set off a correction period. That's a short period of time to fix that problem. They can basically say the repairs were done, but they were done bad. You got to do it again. The seller has a short time to fix those deficiencies. This is generally for those little things that were forgotten. If they were supposed to spackle in nail holes or they missed a spot while they were painting, they have a short period of time to correct it. The parties can extend this as long as they want because the buyer is the one saying you got to fix this thing. But if you fail to do the repairs, the buyer can terminate and the earnest money goes back to them. So bad repairs are not the end of the road in the Oregon Realtors contracts. If the buyer wants to invoke the correction period, they just need to specify the deficiencies and put seller on notice. Hey, this drywall job for filling in the wall-mounted television, it was done really bad. Here's a picture of it. It's obviously done poorly. You can still see like the indent from where they put the fake drywall or the little chunk of drywall into it. It's not done right. You need to fix this. The buyer gets a right to basically take a second bite at the apple and say, okay, seller, you did not do the repairs right. And the seller then gets a chance to do them properly this time. It's designed essentially as another procedural step that lets the parties be reasonable human beings with each other rather than having to like force them to do something at knife point saying, I'll terminate this contract if you don't do the repair. It's built into the contract. Issue 4, automatic terminations. Scenario, buyer is under contract with a Fair Housing Association loan, one of these FHA loans that have some pretty strict requirements about the property and what you can do and your income and things like that. The property fails to qualify for the FHA loan. It happens. Probably the property wasn't the right kind, or it had something wrong with it. It didn't have the right breakdown, or too many bedrooms, or something along those lines. Didn't qualify for the fair housing loan. Step 3, the buyer notifies the seller that the loan failed. Ah, darn it. Now the parties begin their negotiation step to reach an agreement about next steps. What are they going to do next? The parties ultimately agree to let the buyer use a conventional loan, but this is 10 days after the loan failed. The seller is now upset with the contract at a later date, and they argue, well, the contract automatically terminated since we were so late on agreeing to the financing contingency remedy. When your contract says something like the parties will negotiate for 3 days, and at the end of those 3 days, the contract automatically terminates if an agreement has not been met, you don't mess with that. When a contract automatically says it terminates, that's not a maybe. It's not a parties can ignore it if they choose kind of provision. It literally terminates the contract. Upon that happening, upon activation of the automatic termination clause, it's over. The contract is automatically terminated. Proceeding on a contract that has already terminated becomes, even if it's accidental termination or intentional termination, it invites significant dispute that's going to happen in this contract and creates a very real risk of lawsuit. In this context, the contract, let's imagine, says you only get 3 days to negotiate. If the parties took 10 days to negotiate and forgot about that provision that said 3 days in, it automatically terminates if you don't have a solution, theoretically, the seller can always come back and say, yeah, we're actually in a terminated contract right now. I have no obligations. And they might be right, because the contract said it automatically terminated. And so if the seller has a change of heart after this happens, and they say, oh, I got a better backup, I don't want to do this anymore, they might be able to get out of the contract, even though the parties did negotiate a solution, which was what they were supposed to do. In the Oregon REALTORS Forms, we've created a process that basically says there is no automatic termination. Termination rights must be used or they are lost. So for example, in our notice of termination, this is our financing clause. If the buyer loses, it has some kind of a financing failure, they're supposed to send a notice of termination to the seller. And if they send that notice of termination and they do, or notice of failed financing, and they don't terminate the contract, the parties have to negotiate. But when the loan fails, the buyer can simply say, hey, seller, I didn't qualify for the loan, so I'm also terminating the contract. That is the buyer's first chance to terminate. Once you go into your automatic negotiation, if there is some sort of a negotiation that fails, you get your 2 days to negotiate, and that doesn't go anywhere, both parties can terminate. At that point, the buyer and the seller have a right to terminate for a couple days. So the buyer gets 2 chances to terminate, the seller gets 1 chance to terminate. You've already gone through your negotiations. If you wanted to terminate, one of the parties would have terminated at this point. Oops. If the buyer doesn't terminate after their 2 chances, and the seller doesn't terminate with their main chance to terminate after the negotiations have like drawn out too far, we say the financing contingency is released. Basically what this means is there's not going to be this situation where the seller has a change of hearts and later on then decides I'm going to terminate because the contract automatically terminated and we forgot about that. That right, that kind of argument doesn't exist in this context. Instead, you have your chances to terminate. If you don't take them, the contract marches along. So terminate if you plan to terminate. So it's something that must be used. It's an affirmative right. Killing a contract should be an act that you intend to do rather than something that you do accidentally. If the buyer plans to terminate, they do this at the moment where their financing has failed with a notice of termination. If they don't send that notice of termination with their failed financing notice, then they have a chance to terminate, an automatic negotiation period. If the parties terminate at the end of that negotiation period, it's over. If they don't want to terminate, if they're still negotiating, if there's still a chance this is going to work, then the parties are going to work on this and move forward. There is no termination right anymore. Functionally, this means there is no automatic termination. You have to choose to do it. Scenario 5, and this is a huge change in the Oregon Realtors library, and it's one of the main reasons why the libraries are so different, is withdrawable termination agreements. Scenario: buyer is under contract. 7 days into the transaction, inspections are moving along wonderfully, but their appraisal hasn't been ordered yet. Step 2, seller decides they don't want to sell this to the buyer anymore because the market is improving and the seller could just make more money by putting it back on the market. So the seller sends a termination agreement apropos of nothing. They just say, you know what, buyer, I don't like you, so I'm terminating the contract. The buyer feels like that termination is not correct. They say, well, there's no reason. The contract doesn't let you terminate, so I don't feel like you're supposed to terminate that. And they go spend the next week talking to their attorney, and they say, okay, attorney, the seller is willing, it wants to terminate this contract. If I go to do a specific performance lawsuit, what are the odds that I win this thing? You know, if I have to fight them in a court, is there a chance I win this? What arguments do I need to do? They start gathering their documents and planning for this inevitable specific performance lawsuit. Inspection period has ended and the buyer hasn't got that appraisal ordered yet. The appraisal still hasn't been ordered because they're potentially in a terminated contract. At that point, the seller then withdraws their termination. They say, oh, that termination I sent you earlier because I didn't like you, we're going to take that thing back. I don't want to terminate that one anymore. But instead, I'm going to terminate because you didn't order the inspection or you didn't order the appraisal. That's an obligation that you had. It hasn't been done, so you're in breach of the contract, and that's why I'm terminating. Basically, they pull the rug out from underneath the buyer. That termination is not termination anymore. I withdraw. And instead, on top of that, I put a real termination that has a good reason for it because you thought we were terminated when we weren't. A termination that can be withdrawn is functionally a mutual contract that doesn't take effect until both parties agree to it. If you have a termination agreement that says both parties need to sign for it to be effective until both parties sign, the party that sent it can take it back. That's not a termination. The contract's not over until the parties have agreed. In effect, this means that your termination doesn't occur until the other party agrees with it if you have a termination agreement. While a termination is withdrawable, the transaction is technically it's not frozen. It's not like everything just stops in place and any of the obligations of the parties have paused. When someone sends a termination, if the other party hasn't signed it yet and they haven't officially terminated the contract, you're supposed to march forward with all your obligations. If you were supposed to order reports, if you were supposed to do stuff, you've got to still do those things until the other party signs the notice of termination. What this can mean is if you're a buyer that sends a termination agreement to the other party and they refuse to sign it, you've got to continue acting as though you're buying the property, even though you're the one that wants to terminate, because until they sign it, it's not official. You could make arguments that it's official, but that requires a lawsuit. And we don't want to take this to a lawsuit if at all possible. In the Oregon Realtors context, what we did is we just made it a unilateral notice of termination. Delivery of the signed notice is a termination. It's over unless the seller is the one terminating, because the buyer can invoke specific performance. At that point, the buyer has the right to invoke specific performance. If they don't, there's still a dispute resolution. But in the context of a buyer terminating the contract, once the buyer sends the notice of termination, it's over. It's done. It's just the end of the contract. That's the end of the road. In the Oregon Realtors contracts, we will tell you when and how you are able to terminate in any given instance. So for example, a buyer's contingent right to purchase. If the buyer is, for example, the proof of cash funds is not provided at the time of the buyer's offer or counteroffer, the seller can terminate the contract with no further obligations to the buyer by providing Form 5.4 seller's notice of termination with all earnest money being refunded to the buyer. And then in the contract itself, you would just say, sales agreement terminated is ABC123, and this is the reason why we're terminating. This little checkbox here, it's because the buyer failed to provide reasonably sufficient proof of cash fund. That's the reason. So all of the stated reasons in the contract are pre-drafted into the termination notice, and if you can check that box, you know that you've got a sufficient reason. You then just give escrow your instructions. You'd say $4,000 goes to the buyer, escrow company, the escrow agent, and the escrow number. And then the other party would respond with the instructions. If their response is the same as the buyer's notice of termination, has the same escrow instructions as the seller's response, escrow has their instructions, they can send the money out. I see a question in the chat. Can't a seller ask for specific performance from the buyer? No. So theoretically at contract law, a seller can, but contractually the seller gives up that right when they sign any of the purchase and sale contracts that exist in Oregon. The reason for it is it sets up seller's only remedy. Their sole remedy in the case of a termination is recovery of the earnest money. So basically that liquid damages sum earnest money is all seller can ever get back, which means the seller by signing these contracts has given up their own right to specific performance. Now, could they win an argument for specific performance if that clause wasn't there? Also probably no. Specific performance as a lawsuit requires that this be a thing that is truly unique under the sun, which for the buyer, the property is unique. There's no other property that's 123 Main Street in the city of whatever. That is the only one that occupies its geospatial location in the planet. That means the buyer, if they don't get this house, they cannot get a replacement for it that is the same. Whereas for the seller, at the end of the sale, they're getting money. And money is always the same thing as money. It doesn't matter what money you get. It's not there that you need money from the buyer. It's just money in general. And so the seller can't argue that I'm going to be injured in some major way if I don't get the money from this sale, because money is equivalent in all cases and it's not truly unique. So specific performance lawsuits for a seller are arguably impossible to win. You can theoretically if you've got some really, really specific circumstances and facts, but in almost every transaction you'll ever be involved in, a seller cannot win specific performance. So the option of it is foreclosed in the contracts itself. Scenario 6. Minor breaches the default concept. Here's your scenario. The buyer gets an offer accepted on a home that this buyer suspects has smart home features. The seller refuses to identify those features. There's a portion in all of the sales contracts that says, tell them what the smart features are. You know, if you've got a house that's got some weird lock mechanism on the fridge and you can't get it to work if you don't have the code for it and things like that, you need to tell them about those things. If you've got an alarm system in the house or something along those lines, it's a smart feature that meets in with your garage door opener and things like that. Tell the other party about those things because it can cause problems if you don't inform them. So let's say the buyer says, I don't like the fact that you aren't telling me about these smart home features. You're not identifying them at all. I demand the information. And the seller says, no, I don't want to give this to you. Even though the contract says I'm supposed to, I don't want to. I'm not gonna. The buyer sends the termination agreement with a note that says, I'll withdraw this termination agreement as soon as you give me those smart home features. And the seller says, yep, okay. So they sign the termination agreement, it's terminated, and the seller moves on to their backup offer. The buyer was trying to negotiate. They were trying to play hardball with that termination agreement. And instead, the buyer has lost their offer. They have lost the house. That was not the intent. That was not the point. The buyer probably, if they were really kind of being asked about this from their heart of hearts, they would say, you know what? I really didn't want the smart home feature information as much as I wanted the house. I was just trying to negotiate and I thought it was going to work. Instead, I just lost out on the whole thing. That's a problem. It's a game of brinksmanship. Termination agreements are not a toy. They're not something that you should use as a way to force a negotiation. If you send one, you need to be absolutely prepared that the contract is going to terminate and end. Anytime you send a termination, it should be with intent to terminate. It shouldn't be something where you're sending it hoping the other party doesn't push the big red button. This is not the Cold War. This is not how you want to negotiate. For minor breaches and little issues, if the parties don't want to engage in a game of brinksmanship, kind of a zero-sum game where only one party wins in the end, you need to use something other than a notice of termination or a termination agreement because it just doesn't work that way. A termination is the ultimate step, and when it's an agreement, that means the other party can force it to be a final step even if you didn't want it to be one. In the Oregon Realtors Library, we created the concept of default. Something that exists in contract law, but we put it into a form. Default essentially is just a way for the party to say, if you don't fix this thing, I might terminate the contract. Oh, just make me. Don't you worry. I might terminate this thing. I'll turn this car around. You have the right to do that with your notice of default. The notice of default forms are anytime the contract has an obligation. It says a party can do something, but it doesn't specifically say use a notice of termination. That's something you can send a notice of default for. So, for example, in this section, upon receipt of notice, the default, you get your 3-day period to cure. If the defaults aren't cured, the buyer can then send a notice of termination. That's what it does. Is basically say, okay, other party, I'm going to give you 3 days to fix the problem. In this context of smart home features, you'd say, I'm going to give you 3 days to send the smart home features like the contract tells you to do. If you don't get me those smart home features, I now have 2 days to terminate the contract. I have a right to terminate that I have granted myself through your inaction. That's what a default does. You can fix the problem. The party that's getting the notice of default can just cure the thing and send the smart home features information, and now the termination can't be done. But if they stay in breach, if they stay in default, the other party can terminate. The buyer or the seller, whoever it is that's sending this notice of default, has now got a right to terminate the contract for a short period of time. You don't have to invoke it, but you can. The sending the notice of default essentially is your way of unlocking the cage that lets you take, it's like breaking the glass, and you can use the fire extinguisher if you want to, but until you break the glass, you can't get to that fire extinguisher. Sending this notice of default is the way of breaking the glass and saying, I might use the fire extinguisher. Odd example. It's not my best one I've ever given. Metaphors are not my forte. So the way to use this is you would send the notice of default and the opportunity to cure. You'd say however many days it needs to be. You can set more than 3. You can say, I'm going to give you 6 days to send those smart home features. Please do it. You got to do this thing. And it can be, you'll specify what needs to be fixed. For example, hey, you didn't send me all of the HOA documents. Where are the HOA documents? I need to get the bylaws. I need to know how much I'm paying every month if I'm going to be part of this homeowner association. Send it to me. I'm giving you 6 days. If I don't get this information by the end of 6 days, I might terminate the contract. That's a risk you might have to take, seller, if you want to stay in breach. But if you're going to stay in breach, I don't necessarily trust you and I might terminate the contract. If you want to fix it, then I won't terminate the contract, and I don't even have a right to. If you want to have a hard conversation with your client, you need to, like, if you're sending one of these, you need to have a hard conversation with your client and say, okay, what happens if they don't fix it? If you give them their 6 days to fix it and they don't fix it, are we willing to terminate, or do we just want to use this for negotiations? Let the client make that decision because they're the one that's going to end ultimately like pull the trigger on this. But it allows you the option to at least make that half-step measure for negotiation purposes, and it doesn't force you into an accidental termination or an unintentional termination when you were just trying to negotiate. Issue 7, professional inspections. This is one of my proudest pieces of clip art. I created this from all of the free images that you can find on Microsoft Word. It was very difficult to make this look like it did. Here's the scenario. Step 1, buyer and seller go under contract. Step 2, contract has a professional inspections addendum of some sort. A miracle library that has a professional inspections addendum. We don't know which library I'm referring to. Use your imagination. And that professional inspection addendum allows the seller to do home inspections, but the buyer says no to every other inspection other than home inspections. So they go under contract. The buyer sends the professional inspections addendum document, and they say yes to home inspection, but no to everything else. During the home inspection, the buyer's inspector says, yeah, you got a potential problem here. That looks like termites, but I'm not a termite expert, so you're going to want a pest specialist to look at this place because it might have some real problems that I don't know about and I'm not qualified to tell you about. So you need a pest inspection. Oh, no, that's really unfortunate. The buyer says, hey, seller, I got to do a pest inspection. And the seller says, no. Look at your professional inspection addendum. You said no to pest inspection earlier. I agreed to you doing home inspections. I didn't agree to anything else. You already told me you were not doing pest inspections. I don't have to do anything else. This happens more often than you think, but what's the response? The problem is this creates real issues. If you have a list or a document that requires you to specify what you're going to do, your specific inspections you're going to do at the start of the contract, at the initial stage of the contract, this can cause disagreements if you have to change that contract down the road, if you have to change that list of inspections. If you're asking a person to designate or identify their specific things before they know anything about the property, there is potentially change that is going to happen. And the buyers don't tend to know all that much information about the contract, so they have kind of three options. They can either ask for every single specialized inspection and potentially have their offer rejected because they're asking for so many unworldly inspections. Like, I don't want to do the radon test, but I got to check the box because what if I find out I need it? They can ask for reasonable invasive inspections and hope that they can modify it later on, but know that there's going to be potentially a fight over that modification. Or they can ask for no invasive inspections and just hope that everything goes well. The second and third option are not exceptional. The first option is also not exceptional. It forces you to essentially paint yourself into a corner at the start of the contract, and that's not what inspections are about. In Oregon Realtors contracts, we just say you can do certain inspections. You can just flatly do them. If you're allowed to do inspections during your due diligence contingency, but you can also do some invasive inspections without even needing seller's permission. You have to do seller's permission if you're going to be like plucking a piece out of the property. So if you're doing like an asbestos test or something, you have to clip a piece off the flooring. That requires seller approval because you're taking a piece of the house with them as like a trinket. But for other things, for sewer scopes, mold tests, pest inspections, dry rot, radon, and oil tank locates, we don't count those as invasive inspections in the Oregon Realtors contract. If the buyer wants to do those inspections, they can. If the seller doesn't want the buyer to do those things, the seller needs to specify that they can't do it beforehand. The seller essentially needs to say, buyer's not allowed to do pest inspections on my property as like an initial stage in an addendum or additional provisions of the sales agreement. If you're a buyer and you get a counteroffer from the seller that says, love your offer, but you can't do pest inspections, maybe start preparing for there to be a pest infestation because that's kind of sketchy. The buyer, the process for how to do this is the buyer can just hire the inspectors. The buyer gives the seller reasonable notice. So like, use your imagination, be a reasonable human being. It's not 30 minutes before you show up, you call them up and say, hey, we're going to have a radon test today. And the seller needs to provide reasonable access. So schedule around your tenants if they've got tenants on the property. If the inspection triggers a need to do more inspections, just repeat this step. The buyer can go back and say, oh, we need to do a pest inspection now. My home inspector said we might need to look for pests, so I need a pest inspector to look at it. And that's okay. You don't need seller's approval to go back and say, well, the inspector told me there might be other problems. There's no requirement for like second term approval on these sort of inspections. Issue number 8, inspection report prohibition. Here's the scenario. Buyer terminates a contract because the inspection showed a crack in the foundation. The seller frivolously disputes the earnest money for a few weeks, largely out of displeasure that the buyer terminated. This happens. I see a comment in the chat before I move forward. Is it better to state inspections in a general way, such as buyer has the right to perform any and all inspections deemed necessary by buyer, or to itemize inspections specifically? If you are using a contract that has like a professional inspections addendum or a requirement that you get seller approval to do professional inspections, it's usually better to itemize those things because if you put in that, for example, buyer has the right to perform any and all invasive inspections that are deemed necessary by buyer, The seller can approve that, and that theoretically would be a blanket approval, but there's an open question about what is meant by invasive because it's never defined. Typically, it's understood as an invasive inspection is an inspection that requires the inspector to do some kind of a physical manipulation of the property itself. They move siding, they go, they move a pipe, they turn something on, they turn something off, that kind of process. That more than just kind of a cursory review through visual inspection. They have to like get their hands involved in the things. That's an invasive inspection. But because the term is never defined, if you say buyer is allowed to do all the invasive inspections they want, the seller could still say like, you can't do a radon test. That's not even invasive. That's just a radon test. It's its own separate thing. You didn't get approval for that. And that argument is hard to fight back against when there's no clear language. So if possible, itemize and specify because it clears up any legal disputes you have. If you just need to do a ton of inspections and you don't know what you're going to be doing, general terms are sometimes better, but I would say from the risk management perspective, specificity is always preferred. It is the better approach for kind of protecting your contract and your client. So back to scenario, buyer terminates because they saw cracks in the foundation. Seller is angry about this buyer termination, and sometimes sellers move emotionally rather than logically. And so the seller frivolously disputes the earnest money just to like tighten the thumb screws on the buyer. This happens. It shouldn't, but people aren't necessarily nice people. The buyer is now upset with the seller and sends the seller the inspection report and says, now you got to tell everybody about the cracks in your foundation. That's going to cost you money. Congratulations. Should have just given me the earnest money. This sort of thing happens. The seller enters into a contract with the next buyer, but doesn't disclose the inspection that talks about the cracks in the foundation in the SPDS. They don't even say there was an inspection because they're like, it wasn't my inspection, it was the buyer's inspection. The new buyer's home inspector does not notice the crack in the foundation. Now that's a lawsuit for the home inspector, but let's just move with it in this scenario. The buyer, the original buyer, contacts the new buyer. It's a small town, they all know each other, and they tell them about the crack. They say, hey buyer, did you know about the crack on that property you're trying to buy? And the buyer goes, no, I didn't know about it at all. My home inspector didn't notice it. And this new buyer, or the old buyer, says, well, guess what? There's a crack in the foundation. My inspector found it. That's a huge problem for you because that's an expensive repair. The new buyer terminates the contract based on the seller's misrepresentation. They say, seller, you got an inspection report from your original buyer. I talked to them. They knew. I know that you got that report. Where's the inspection? You should have told me about this thing. I should have known. And therefore, I have a right to terminate the contract, cancel this contract, and I want all the money back. I want the money back for the cost of my inspection because I wouldn't have even gone into this if I had gotten a copy of that inspection report, or the original one that you got from your original buyer. So it's all on you, seller, and there's a lawsuit that starts. Now, you might have a contract that says something like you can't send an inspection report. That's nice. Oregon law does little to enforce that provision. Functionally, it's the same thing as this fun little meme from The Simpsons, keep out or enter, I'm a sign, I'm not a cop. That's what your contract essentially does in these provisions where it says, don't you do this thing, because all you can do at that point, if someone does send an inspection report when the contract says you can't send an inspection report, all you can do is sue that person for breach of contract. In a breach of contract dispute, you have to be able to prove damages. What was your damage from that buyer learning about the inspection report? The new buyer terminated on the contract because they found out something true and actual about the property. That's not damage to the seller. That's just essentially it's a true fact that came to light. At worst, this sort of a can't send an inspection report contract provision creates confusions and structural conflicts within the contract. At best, it just kind of enforces nice people to follow the law. But what we don't have in this situation is what do you do when things go wrong? And forms are generally drafted around the concept of fulfilling all of those worst case scenarios and kind of bridging legal risks that could exist. So when you put in a provision that causes its own separate legal risks, it causes problems. In places like Washington, they have these can't send an inspection report provisions, but they also in their MLS rules and various other rules, they have enforcement mechanisms, and Oregon doesn't have those yet. Once we have those enforcement mechanisms, we can put those don't send an inspection report sort of provisions in a contract anytime you want because there's some teeth in it. But when there aren't teeth, there's no enforcement when someone does violate that provision. The seller's not able to pretend the report doesn't exist. They simply have to disclose in the SPDS that they have received this inspection report. Otherwise, they're misrepresenting the facts. And so when a buyer who's been terminated on maliciously sends a report to the seller, your SPDS should be updated accordingly, even though that buyer is violating the original contract that they had signed between the parties. You can't terminate on them again, so what are you going to do? In this instance where the buyer is kind of manipulating or getting involved in someone else's contract, you could claim it's a tortious interference with contract. But what's the tortious interference? Telling the new buyer, the truth about the property? That's not really super injurious to the parties in this contract. In the Oregon Realtors Form, what we decided to do after a lot of discussion was to say silent on the issue of sending a report without permission. So with no contractual punishment in this one, that functionally means any party that wants to send the inspection report can simply send it. There's no thing where the seller can tell the buyer, I don't want the inspection report you did about my property. You can't send it to me. If there has been arguments we've gotten, which is sometimes that people say, it's like, well, if the new buyer can send an inspection report to my seller, what if that inspector was wrong? My seller's been injured because they got a wrong inspection report that they now have to tell everybody about. It puts a black mark on this property and lowers the property value. Why does my seller have to disclose that report if it's wrong? Doesn't that mean the seller is injured? Well, here's the problem with that argument. Under Oregon law, inspectors are certified and essentially licensed individuals. If you are a real estate agent, you are not, under your code of ethics and under Oregon law, you are not supposed to act in some way that is outside your expertise. Home inspectors are literally experts at the concept. And if you're telling a seller that home inspection's wrong, you don't have to listen to that thing. You're acting as a home inspector. That is outside your expertise. That is punishable under the code of ethics. It's punishable under Oregon law. You should not be pretending to be a home inspector or even opining on home inspections. At most, you should say, seller, if you don't like that home inspection, you should have your own home inspector look at it, because if it's wrong, your own home inspector will be able to counteract that. And you can then say, we had 2 home inspectors look at it. My guy who looked at it more recently, and I very much trust, said there's no problem. That's your only real option, because the realtor, unless you are a licensed home inspector, should not be making opinions on home inspections. The sometimes an inspector is wrong situation. This is the best case scenario. Outcome 1, the inspector was wrong. The seller has to disclose the information that they have information from a licensed inspector that is untrue and is otherwise backed by a certified inspector's word and licensure. If the seller refuses to disclose that information because the broker advised them to, and the information turns out to have been untrue, the broker violated ORS 701-445. They did an inspection without actually having the certification, and Article 11 of the Code of Ethics, as well as potentially 696-301. So there are 3 prongs that you can get smacked with on that one because you were acting as an unlicensed inspector, but it was an untrue inspection. There wasn't a crack in the foundation, so at least that's not a problem. In the worst case scenario, the inspector was right, and the seller was supposed to disclose that information, but the broker told them, don't disclose that. That inspector was wrong, and you were wrong. The inspector was actually correct. There were cracks in the foundation. At that point, you have a violation of 701-445, an Article 11 violation, a 696-301 violation, as well as the seller potentially being sued for misrepresentation or concealment of a known fact. So when you pretend that an inspector is wrong, or say you don't have to tell anybody about that inspection report because that was the buyer's inspection report, you weren't even supposed to get that thing, you've created potential serious problems for yourself down the road, because essentially you're not licensed, you're not qualified to tell your buyer whether the inspection is correct or not. And if you are not really qualified to tell them whether or not the inspection is something that injures them or doesn't injure them, and so the baseline is you should really be sending those inspection reports whenever you get them. It's a little bit circuitous, but that's the reason why we basically said you can send them. If you're a buyer and your contract is terminated on, you're angry at the seller, send your inspection report. Seller, the worst case scenario, you've learned something about your property. Wood stove repair issues. Scenario 1, seller is selling a home that has a wood stove. Seller is supposed to remove the wood stove before closing. Seller removes the wood stove. The stove pipe where this wood stove was spewing smoke out into the world, that has also been removed, but now there's a hole in the ceiling. Well, seller was removing the wood stove. All they had to do was remove it and destroy it. There was nothing about repairing it. So the buyer walks into the house on day 1 and they see a t-shirt stuffed into the old chimney hole. It literally happens. This is not the best case scenario. This is the buyer is their first angry question you will always get after they wander into the house expecting to have like the dream home is, why is there a hole in the roof stuffed with soggy t-shirts? The wood stove addendum, kind of the classic wood stove addendum you've been using before Oregon Realtors Forms, it does nothing to address what the parties are supposed to do when the stove is removed. It might be something that's attached to the wall. When you pluck it out, are you supposed to fill the spackle holes in the wall where the stove used to be? If there's a place where it was, where the carpet was removed, do they need to put carpeting back where it was to fix it? That question is never addressed. And so you have this problem when a stove is removed of potentially having what looks like damage to the property, but it's not. It's just the stove used to occupy that space and now the stove is gone. And the seller has a very reasonable argument to say, I wasn't asked to fix it, I was only asked to remove the stove. In the Oregon Realtors documents, what we did is we basically put a space in there where you could say, is there an inefficient device that needs to be removed? Yes, no. If yes, will the seller be fixing that? If the answer is yes, then seller is supposed to fix it. They're supposed to repair that. If the answer is no, start telling your buyer you might have a t-shirt whole stuffed, whole stuff of t-shirts that they'll find at the end of this transaction. It's at least a notice. At best, it's a solution. Legal issue number 10. Accepting an expired offer after it has expired. Scenario. So buyer has an offer that they give to the seller. It expires on January 6th of 23. Seller forgot about the offer. Oh, they're bad. They don't get around to it until the 7th of January after the expiration date. The seller accepts the offer on the 9th of January. They go, you know what? It's still the best offer. I want to accept it. The buyer doesn't want the house anymore and terminates for no stated reason. The buyer basically says, you know what? At a later date, the idea behind this is the contract moves along for some time. The buyer's under contract for, let's say, a week and a half, 2 weeks, and then they say, you know what, I don't want this house anymore. It's just not for me. I don't have a reason to terminate. I didn't, the inspection. I waived the inspection originally. None of this is working. I don't have a reason for it, but I'm just going to terminate because the offer was expired. You accepted an expired offer, seller, so we're not under contract. When an offer expires, it is technically dead. Offers have to be accepted before they expire. When an offer is expired and dies, you can't move on it. You can't act on it. It's a permanent fault in the contract that basically says this agreement was not supposed to be. If you accept a contract after it expires, you're essentially creating a zombie contract. It has been risen from the dead and it's not supposed to be here. It is an unholy creation. That means the contract is arguably voidable at law and it spawns potential lawsuits into the future. If you just accept a contract after it expires, normally if I have a contract with you and we don't have a contract in writing, the contract, let's say it expires. I say, I want to buy your apple. You're selling apples and I want to buy an apple from you for $1. And I want to buy that apple by tomorrow. And you don't respond to me until 2 days later. And then 2 days later you say, oh, I still want to sell the apple to you. And I go, okay, here's $1. What normally happens at law is we say, okay, the parties didn't have an agreement in writing, but through their actions, we can interpret that as a contract. They've agreed to something through their actions. By acting upon that, by me handing you $1 and taking the apple from you, we can reasonably interpret that as there being a contract. The problem, though, is real estate contracts have to be in writing. And if I accept your voided contract, that's not acceptable. It's in a contract that shouldn't be. It shouldn't exist. And then at a later date, I decide we don't have a contract anymore. You can't say, well, understandably it was void contract, but actually I think it was valid because we've acted upon it for a while. If we don't have a memorandum in writing that makes that a literal written contract, it's in violation of the Oregon statute of frauds. These post-expiration acceptances of contracts are literally a contract that either party can say it doesn't exist anymore, I want out, until the end of the contract. Is an unlimited right to terminate that really can't be argued with because the contract was never supposed to be. In the Oregon REALTORS Forms, we have a solution to that, which is basically you can't accept a contract after it expires. If it expires, it's only acceptable with a late acceptance addendum. A late acceptance addendum is functionally just a pre-drafted counteroffer. It is a counteroffer that says, I got your offer, I didn't accept it before it expired, my bad. The new offer is going to be given to you. You need to accept it within a day. If the party accepts it, congratulations. You're under contract. You have a counteroffer that's totally valid. You have not got a zombie contract. It's a counteroffer. This means that you're under contract and you actually have like a valid, legally binding contract that doesn't have statute of fraud questions. It is a new offer that has been legally accepted by both parties. Functionally, how it works is essentially the buyer would present the offer to the other party. It expires. Seller sends the late acceptance addendum. Buyer signs it and accepts it. At this point, if there is some sort of a change of heart at some stage down the road, you're under contract. So you have to have a valid reason for termination. You can't just say, oh, but our offer expired. That's why I want out, because that offer is no longer, that is no longer an acceptable answer. Issue 11, and this is where we start getting into the more kind of hot button topics of the form library world that we're in now. Counter-offering onto a different form library. Here's your scenario. An offer is presented to you and you don't have a subscription to the form library that they're using. The other form library has restrictive licensing agreements that prevent you from getting the needed forms. I see question in chat. If a contract expires and the seller intends to sign on time, can you write language in an addendum that makes the current contract with the buyer and the seller signing of the addendum? So if the contract expires and you put an addendum on an expired contract, it doesn't do anything. It's kind of like lipstick on a dead animal. It doesn't make it alive again. If you do a counteroffer, yes. If you have an addendum of some sort that's in writing, there's an argument that you've materialized something in the statute of frauds, but it's never been hashed out in the courts, and we can't actually tell you how it would go because nobody knows. The simple answer is if your offer has expired, you need to offer it again or else it's not valid. If I have a dead offer and I say, well, that dead offer is going to be alive until next month, there's no necromancy that brings it back at law. It just doesn't work that way. And so the general addendum does not revive an offer after it has been terminated, in the same way that when I withdraw an offer, you can't accept it after I withdraw it. That's kind of the reason why it doesn't operate that way. If the offer hasn't expired yet, the offering party can extend it. I can put an addendum on my offer until it expires that says, actually, the expiration date is way out in the future. And until it expires, I can amend it. Once it has expired, I'm kind of locked in where I am. So scenario 12 or 11, you got an offer that's presented to you on a library contract that a contract library you don't have. That library's licensing agreement says you can't get these forms from the other party. You can't just ask for them and they'll give it to you. You need to counteroffer because you don't have those forms onto the form format that you do have. Counteroffers will only change what is specifically stated in the form itself. It incorporates all the other language. The counteroffer literally says, we accept all the terms and conditions of the previous offer or counteroffer with the following changes. If you counter improperly, if you just counteroffer and say, you know what, counteroffer, here's my counteroffer, I want it to be on Oregon REALTORS Forms. If you're moving from some other library to Oregon REALTORS Forms and all you said is, I want it to be on Oregon REALTORS Forms, you have not changed the undergirding language of that original offer that has all of the original contract terms of the other library. So that means you've accidentally mixed the library, even though you're asking to put it on Oregon REALTORS Forms, it didn't go that way. What this means is you create problems with the contract. For example, on Oregon REALTORS Forms, we say you got to use our termination documents because they're designed to work with our library. You got to use our repair addendum because it's designed to work with our library. Most contract libraries are drafted in the same way, which means if you have a conflict between the libraries, it's going to tell you use our library if you're terminating. So for example, let's imagine you have an ORF offer and you say counteroffer on Oregon REALTORS Forms. Here's an addendum that we also want to add to it. It's an Oregon REALTORS addendum. The addendum might tell you to use Oregon REALTORS termination documents. The sales agreement might tell you to use termination documents from ORF. That's a mixture that you can't really fix if you've done this counteroffer improperly. Functionally, and this is a silly example, but bear with me, this is the visual for understanding counteroffers. Let's say you have a client that says, I want a contract that has a picture of a horse on it, and then someone counteroffers and says, no, I don't want a picture of a horse on that. I want a picture of a creature with one horn, like a unicorn. I want a one-horned creature. What the counteroffer does, what people think is when you say, oh, you replace it with a one-horned creature, it replaces the whole thing with the intended thing. You got a narwhal. Great. You've replaced your horse with a narwhal. That's what it did. It replaced the whole thing. It went from horse to the new concept, a full change. What a counteroffer actually does is it only changes the part that is needed to change. So what a counteroffer really does is it just snips the one part that is being overwritten and puts something else on top of that one part. Everything else remains the same. In some cases, this can create an abomination, as you can see in the image. That's why counteroffers need to be used carefully, because if it's used wrong, you'll create something very unintended. We have created a special document in the Oregon REALTORS library, Counteroffer 2.1a, that specifically hops you onto an Oregon REALTORS form library. What it does is it ensures that the counteroffer process that switches you onto the Oregon REALTORS forms doesn't go wrong. It is a counteroffer, but in addition to that, you're rejecting all of the terms of the undergirding offer, and instead you attach an Oregon REALTORS offer, and that has all the terms on it. It sounds like a lot because you're basically rewriting the offer for yourself, but this is functionally the only way that you can ensure that you don't have a mixture of forms that goes wrong when you are changing libraries, because it is not just changing lanes on a highway, it's changing out of a car and into a boat. That's the difference of libraries. Functionally, the way to use this is quite straightforward. You use the counteroffer form 2.1a and you say, here's my counteroffer to Oregon REALTORS Forms. You would fill out a form 1.1 or whatever your purchase and sale agreement is and all the addendums that you would need with it, and you would attach that as a packet to the back of that counteroffer form 2.1a. You would then attach that whole thing and deliver it to the other party and say, here's my counteroffer. It's the following. You can accept it or reject it, up to you. At that point, you've swapped the whole library onto the Oregon Realtors world, and at that point, you don't have this form mixture question that's going wrong. You've done the counteroffer in the way that kind of law intends it by doing a full rewrite and an overwrite. The last issue, the 12th issue, is the for sale by owner licensing conundrum. Scenario: your form company operates for profit and has a licensing agreement that restricts you from directly or indirectly providing copies of that form to any third party unless you are directly engaged by that third party. You have a buyer who wants to purchase a home from a for sale by owner party. The owner is willing to write out the contract on a napkin, but they don't have forms. They don't have a subscription to that form library that you're using. They want you to provide the forms to help do this transaction. So what do you do? The reason why this creates risk is if your licensing agreement doesn't expressly or clearly allow you to share forms with some kind of a for sale by owner party, if they haven't hired you, you aren't supposed to share the forms. And the for sale by owner party doesn't hire you. They are actively not your client. So if you have a form that you give to if you do, for example, provide that licensed form to the for sale by owner person, the licensing agreement is breached and you might have some serious problems. It could be, for example, 3 times the subscription fee as a liquidated damage sum, and they could terminate your usage or access to the form based on unauthorized usage by the for sale by owner party. Now, when we talk about this in abstract, it sounds kind of interesting. When we use the actual literal, this is a licensing agreement example. It talks about exactly what you can and can't do. Scope of the license. Your right to use the forms is limited and personal to you. You are not licensed to provide copies of any form to any third party unless you are directly engaged by such party to represent them. What can they do if you're using it wrong, if you're breaching this agreement? Terminate your access to the forms and terminate your license to use the forms. And in addition to that, they can also go after you for liquid damages equal to 3 times the fee charged normally by OREF. This is literally on their website. If you want to look for it, it's right here, orefonline.com/OREF forms license terms and conditions. You have to agree to this if you're using your OREF forms. These are the terms and conditions. This was updated in May of this year. These are the most modern version of it. So this is a very real problem, and this is quite literally the public information that must be agreed to. So open question: what do you do if you've got a for sale by owner party that wants you to give them the forms so that they can do the transaction? Do you give them the forms, or do you just let the for sale by owner party write it out on a napkin and hope that it all works for the best? In the Oregon Realtors Forms context, the way we fixed that is our licensing agreement says, look, as long as it's a realtor using the form, we don't care who you're sharing it with. Help your client make this transaction work. The user may provide Oregon Realtors Forms to any unrepresented seller or buyer in a real estate license, or to a real estate licensee on the other side of the transaction who is not an Oregon Realtor. The user may not provide them to non-Oregon Realtors members for any other purpose, but as long as you're helping your client in the transaction, go for it. This doesn't mean you can give let your cousin use our forms because your cousin doesn't want to hire a realtor. But what it does mean is, I'm sorry, just bumped my computer and my visual just went all haywire. There we go. Screen sharing. Excuse me for a second. Get this all started up again. Technical difficulties. This is why we don't do live theater. Oh, come on. We'll do the screen share over on the other screen so I can get there. There we go. There we go. This is the way we fixed that problem. We basically said, if you are dealing with an unrepresented seller or a buyer, you can just give the forms to them. As long as you are on one side of the table, you can make that transaction work. Not being motivated by profit lets us kind of share the forms in a more forgiving manner, and that was kind of the express intent. Now, how do you do this? What's the function for it? The process is quite straightforward. Oh, that's obnoxious. Let's do it this way. I'll do it this way. I'll do this. I'll start the slideshow. Oh, my goodness. My screen share is just a mess today. There we are. This is the last slide too, so I apologize for this sudden delay at the very end. It was my best visual too. I'm very proud of this animation. You would simply give them the forms. As simple as that. The goal of the process is that if you really do need the other party to use the forms from Oregon Realtors, you can simply share the forms. You can hand them over to the other party and say, use these in our transaction. I'm the buyer's agent. It helps me. If you, for sale by owner party, can use these forms, it's simply the best for everyone. And that's where our slideshow ends. Apologies on the sudden bump on that one. If anyone has questions, I'll stick on for a little while, but otherwise that's what we've got today. Those are 12. In the original version we'd done this, we had, I think, 18 separate issues that we had addressed in the forums. With only an hour, we only did 12 of them. But if you have other questions or other comments or thoughts, let me know in the chat. Otherwise, we have an open house that we'll do from 11 to 12 each day, where you can kind of go in and talk to one of the attorneys at Oregon Realtors and just see how your transactions are doing, or ask questions about forms.